construed within the context of my preliminary comment, then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been done. So, let me finish.
With all due respect,
you allow the minority leader. I'm responding to his
asking
objection.
the minority leader to raise an issue. Order.
I am responding
Order.
I'm responding.
Honorable minority leader.
Let me respond.
Honorable minority leader, hold it. Honorable minority leader, hold it. May your microphone be off, minority leader.
Chairman, just a second.
Minority leader, let your microphone be off. Hear me out.
Very well. I will hear you.
I'm supposed to play the fair game here.
If you make your point, we respond.
Honorable minority leader,
What is wrong?
please, just observe me.
The Premier boss spoke
Hear what I will want to say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly and panel acted in conflict. I mean, all those things.
You've said that. You've said that. You've said that. You've said that. You said that. You said that the nominee swiftly empaneled the court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter. Then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman.
No.
Chairman.
I have the floor. You've not called.
Chairman, the rules.
And you have not called.
The rules.
Chairman,
The rules.
Chairman, he puts on the right.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear, Chairman. The rules. Though when you just comes in, but you just put on your microphone and speak. Put on your microphone and speak.
Honorable members, I've stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the Majority Leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement. If we consider this motion, you shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it.
Okay.
Not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee, because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response. The Majority Leader has raised his issue, and then the Fiamako also brings in a different issue. So I'm done with him. Let me now address the Fiamako's issue, the Majority Chief Whip. The Majority Chief Whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that. Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the first deputy speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the majority chief whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the majority leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice Arabe Esabatokonu has rights, far rights. And what becomes of her when eventually the court determines that all her beliefs are upheld, and then what becomes of us? What
Majority Leader.
You are hearing?
No, I am the one speaking.
What do you want?
You understand? Yes. Please, let's take a cue. Several, I admonished that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them Sunday. That is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt. They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman. Chairman. But you can't be jumping from this issue. Chairman. What the majority leader is doing, is not fair. He raises his issues. You don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours. Because
Honorable members, order.
When you are talking,
honorable members, on this note, we will break for cocoa. So it's time for cocoa break.
And so yes, the committee will go for a break without even a single question to the nominee, and that's because for more than an hour the committee could not get past the initial comments by the minority leader, and so for more than 1 hour the committee has been dealing with attempts by minority leader Alexander Kwame Afenyo-Markin to have a bite, and as we knew, to speak to the reservations of the minority, and then also the majority led by its leader, and that's Mahama Yarega, making it a point not to move an inch and cede ground for the point to be made and for the Hansa to capture same that the minority registered its displeasure, its disquietness, especially on the back of a number of legal issues that have come up, specifically the active cases in court bordering on the removal of Justice Gertrude Arabai Sabato Konu, Chief Justice, 7 of them to be specific. Mama Yarega says no, these are pending matters, and as a result, the minority leader should not be allowed to speak to them. At the point, there were interventions from other members of the committee: Frank Anodompre, Hassan Tampuli, Roxy Nelson Dafia-Mekpo, and then also Habib Idrisu at the point. But one thing was clear: the majority was not willing to cede ground to allow the minority make its point, because the argument is that it breaches the rules of engagement here in Parliament per the standing orders. It equally breaches the rules of engagement specifically to the 1992 Constitution. So, yes, if we're ever in doubt as to how far this will travel, the evidence is what we are looking at clearly, that yes, the minority had reservations. At the point we felt the minority was not going to be party to this exercise, eventually the minority showed up and then proceedings started. But that hurdle of getting the minority leader to make his submissions, after which, if the chairman of the committee, Bernard Ahiafo, is minded, he also make his submissions, is one hurdle that we've never been able to cross. And if what happens here is anything to go by, I doubt that the backroom engagement that we expect to happen, because I'm sure that's why the chairman had to call for this break, those backroom engagement will, first of all, allow the majority leader to cede ground and allow the minority leader to make his point, or make the minority leader see reason that on the point of law, on the point of procedure, on the point of constitution, those cases pending before the law courts should not be imported into today's conversation. If an agreement is not reached, if grounds are not ceded, then it doesn't matter this engagement that's taking place between Bernard here for the chairman and then Justice Puaman. Mind you, the work of the Puaman committee came up for discussion as well, where Alexander Kwame Afenyomakin, the minority leader, described the work as opaque and shrouded in secrecy. In essence, fell short, just a little short, from describing it as a sham. But mind you, it is the work of the Puaman committee that resulted in the removal of the Chief Justice, Araba Isaba Tokonu, and her subsequent, as a Chief Justice, and a subsequent removal as a Justice of the Supreme Court. And so that's exactly what we are witnessing here. We have covered no ground. And I'm sure those of you watching GHOne TV and listening on Star FM and then also on Empire FM, I will know that no ground whatsoever has been covered. Not even a single question, not even how are you, has been posed to the Chief Justice nominee. But of course, to say this has come as a surprise, I don't know whether, Council, briefly, GHOne TV, your own house, what you have witnessed, right? First of all, no progress. What do you make of it?
Well, you have said it yourself. There's no progress. Well, they said they are using the rules of Parliament and trying to make sure that the process goes according to the rules. So we are also watching. But one thing I'll tell the general public that if it was in the court, you would tell us that the courts are wasting time. Now you see what fine points of law can do. Both of them think they are right, and I believe that...
Couldn't we have just ceded grounds, little grounds, to at least allow the process to continue?
Well, I think now that they have a break, I'm sure both leaders will meet the speaker, and in fairness, the people who are here will be able to make some progress, because we've been here since the process was supposed to start at 11.
Not even how are you has been asked of the Chief Justice.
Not even mentioned his name. It's unfortunate, but well.
Appeal to them. They are watching. What would be your appeal to the leadership of the committee?
Well, like you said, I mean, they should concede ground. And you see, it's interesting. I think both of them are right. The minority leader is trying to lay the ground and the process which has brought us here. The majority leader is also saying that this whole issue has been debated upon in Parliament and a ruling made. So he doesn't see why it should be entertained here. I believe that they will find a way, and we will be waiting.
Thank you very much, former GBA President Tony Forson. And so, yes, in fact, many people here have seen the Attorney General himself, and who was referenced here, not on record, of course. He was seated. His deputy, Dr. Srimsai, seated as well. Let's continuously try to engage from one former GBA president to another. I just engage. Oh, yes, he doesn't want to talk. But of course, the point is that no progress whatsoever has been made. No progress whatsoever has been made. And this break, many people are hoping, is a break that is much needed to allow some cool heads to prevail, and also ensure that when the committee returns and sitting resumes, the Chief Justice, at least the Chief Justice nominee, will be allowed to mention his name. As you heard the former GBA president say, not even his name has been taken or has been mentioned for the record. So if we're ever in doubt that this is going to be a very long haul, the evidence is what you're witnessing. We are yet to clear the very first phase of this hurdle and move. And so let's still be engaging people, of course. Yes. First of all, briefly, because I know you're having your private conversation, but we're live on GHOne TV. First of all, what do you make of what I just transpired? Briefly.
No, please, let me finish with my Lord. Yes.
Yes, so I don't want to go to my Lord, yes, but of course, the point is that the committee has gone on break. And the break is ostensibly for some backroom engagement to ensure that coup has prevailed. But what I'm seeing is that the minority members have filed out, many of them at least. But I'm seeing the chairman of the committee, Bernard here for the first deputy speaker, here. And he's in an engagement with other members of the committee. So if the anticipation is that there will be some backroom engagement, at least for now it's not happening, because I've seen the chairman of the committee, Bernard Ahiafo, here in a conversation with Isaac, who I'm a member of parliament for Efia, and also a member of the committee. I've equally seen Ricky Tegan here, who is the deputy vice chairman for the committee. So like I said, the minority members have filed out, led by Alexander Kwame Afenyomaken and many of his charges. Let's engage. Honorable, briefly. You are live on GHOne TV. What do you make of what this one?
It's annoying. It's irritating. What is this behavior where one person thinks that he knows it all? Everybody must bow to him in the name of multi-party democracy. What rubbish is this that going on? It's annoying and irritating.
Well, so it's annoying and irritating, and that's a member of parliament for the GHOne constituency. I said it's annoying and irritating, but of course, we are still on break, and so we'll have to wait and see the engagement. But the appeal is that no matter what it takes, grounds must be ceded for the sitting to resume, and for the reason why the Chief Justice nominee, Justice Paul Baffoe-Bonnie, showed up here, which is for him to take questions from members of the committee, and he, in return, answering those questions for the committee to test his ability and his capacity to occupy the office as a Chief Justice, will get underway, and that will be done. Off record, you hear some members of parliament, some members of the committee saying that regardless of how long it takes, Alexander Kwame Afenyomaken was not going to be allowed to make his point, because on the point of law, that was wrong. Again, that tells you that we are in for a very long haul. We are in for a very long haul. The Attorney General, as I mentioned, is here. Is now in engagement with the chairman of the committee, Bernard here for the first deputy speaker as well, and many other members of the committee. And so we are on break. But mind you, this is no lunch break. This is a break because there was no any semblance of progress relative to today's exercise, and that is the vetting of the Supreme Court Justice nominee, Paul Baffoe-Bonnie. So back to you in the studio. We'll take that first break and return when the committee returns. Hopefully, by then, coup heads might have prevailed, some grounds might have been ceded, and there will be progress. Because if you watch behind me, dignitaries, many of them advanced in age, showed up here to witness today's exercise. Some to offer support to the nominee, some to fulfill a constitutional duty. Some of them are justices of the apex court of the land. For them to be seated from the 11 a.m. that was announced, because they were here way before the 11 a.m., for the committee to even begin sitting way past 11 a.m., and for us to come to the realization that after hours, no progress, because nobody is willing to cede ground. Not the minority leader, not the majority leader, and certainly not any intervention from the chair of the committee. So back to you in the studios. We'll return when sitting resumes.
Into all this tension just to reintroduce that broke boy from Kaswa.